Morning. Are you Kelvin Johnson? And this is 25 DCCR 1781. Mr. Johnson was previously in court, entered a plea of guilty to the state jail felony offense of theft of property with previous convictions. Entered pleas of true to prior convictions, making this a third-degree felony enhanced. The agreement was for a cap of 5 years in prison. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor.
Any additions or corrections?
Not from the defense.
All right, Mr. Rojas, you may proceed.
Thank you, Judge. Obviously, Judge, when you look at this PSI with stand out its criminal history, it looks rather lengthy on paper. I'll point out to the court that most of the misdemeanors, anyway, are trespassing cases. And I would guess that Mr. Johnson tells me this is the case that most of those, because he was homeless, didn't have any place to go. And as the court knows, if you're homeless and don't have any place to live, you're going to probably get some trespassing cases. He does have 2 prior cases which where he got probation and was revoked. I understand that's not a good track record when we're here asking for probation. I will point out that I think the most or the felony probation case was in 2000, and the one where he was revoked on the misdemeanor was in 2020. So a little bit of time has passed between those two. As far as this current case is concerned, at his statements, he looks like he was stealing food and clothes, necessities. $72 worth, which would ordinarily be a misdemeanor, but with the fact that he already has his 2 prior theft cases, and the other felony case would bump up to a 3rd degree. He's asking for probation, Judge, and again, the felony history anyway is from the last felony case is from 2003. It looks like 23 years ago. He tells me that prior to being arrested, he was working for a church, being paid on a daily basis. I also did some work for a car dealership out in Silsbee. He tells me he can go back to both of those jobs. The car dealer, he doesn't have transportation, but the car dealership picked him up and brought him back and forth to work. So that shouldn't be a problem as long as that job is still there. According to PSI, he's going to be living with his mom. So we're asking the court to consider probation, a deferred probation term. If the court is not inclined to do probation, I would ask for the minimum term on this 2 years, given the fact that things he was stealing necessities and the length of time since his prior felony convictions.
Thank you, Mr. Rojas. Ms. Malfino?
Judge, I don't think he's necessarily not a candidate for probation. I think it should include safety. In my opinion, I would, if the PSI reads as if he expressed interest in that, I would like to ask him if he really wants to take advantage of that. Otherwise, we're just going to be back here in your own situation.
And I apologize. Mr. Johnson did want to speak to you.
All right, go ahead, sir.
So the first charge I ever got, it was in 99. I did my time. I got out. I had a family. I lost it because me and my wife got into it when she took me to some exam. I not gave up, but I became homeless. I got all them trespasses. Then I started stealing food and clothes out the store. But being in the county for the months I've been in there, I see it was wrong. You know, one thing about me, I live and learn. But 2 things happened as I was doing what I was doing. I stole out the store, and the police came up to me, which they didn't bring me to jail. He told me this one thing. He said, "You didn't have to do this. They would have gave you the food." And then showed me instead of stealing, I could just X. And then another time I was panhandling on College Street at the burrito place, and across the street was a car wash. And instead of me, and I looked and I thought about something, and I crossed the street and I started asking them to wash their cars. So what I'm getting at that is, it's better to work than to be doing all that. You know, it's a different way that I'm gonna go by doing things this time. You know.
How old are you?
45.
Yeah, time to start doing things
Yes,
different, huh?
ma'am. Yes, ma'am.
Anything else?
No, Judge.
So here's the thing, Mr. Johnson. If I give you an opportunity today, it's probably going to be the worst I could do today is give you 5 years in prison. If I sent you to prison, you'd be out in 2 or 3 years, and that'd be it. If you really want to change your life and you want probation, it's going to be for a longer period of time. And if you violate, the sentence could be for a longer period of time. It's going to require safety so that you can have the tools to be successful, to not turn to alcohol and drugs and things like that. So I'm going to kind of leave it to you. If you really want that opportunity, I want you to take it. I'll give it to you today based on you've been very upfront. Your history is all clearly because of homelessness and drugs. I mean, that's clear. So if you want to change, I'll give you that opportunity. Is that what you want?
Probation?
Mm-hmm.
Yes, ma'am.
Okay. So here's what I'm going to do, Mr. Johnson. I'm going to find that you entered your plea of guilty freely and voluntarily previously. Find sufficient evidence to find you guilty, and at this time find you guilty of theft of property with previous convictions. Find those prior convictions that you pled true to, true. Sentence you to a term of 10 years in the institutional division of the Texas Department of Corrections, but I'm going to suspend that. You'll be placed on probation for 10 years. You'll be ordered to follow all of the rules and conditions of probation.
Yes, ma'am.
That is going to include entering and successfully completing the safety program. So you'll go to the inpatient part of safety in custody, and then you'll get out, you'll have aftercare. All of that's going to help you find a place to live, get hopefully a job, stay clean, do everything you're supposed to. If you do everything you're supposed to, then for all practical purposes, your case here in court's over. You'll be able to serve that 10-year sentence while you're out on probation. But the other side of it is if you violate your probation, I'm going to see all this history. I'm going to wonder why I gave you this opportunity, and you're going to end up with that 10 years that I just gave you. You understand?
Yes, ma'am.
All right, so I'm going to hand you the trial court certification that shows this was an agreement that I followed, so you have waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. Good luck to you, sir.
Thank you.
Good morning. Are you Mark Anthony Newell? And Mr. Rojas, will your client waive the formal reading of the motion?
You will, Your Honor.
Mr. Newell, in clause number 23, BCCR 0916, I have a first amended motion to revoke your community supervision. Shows that you were placed on probation July 2nd of 2024 for the state jail felony offense of evading arrest or detention with previous convictions. And that was a 2-year term in the state jail prison that was probated for 5 years. Is that correct? Answer out loud, please. Thank you. It alleges you violated your probation. Count 1 alleges that you failed to work faithfully at suitable employment and provide verification of that. Is that true or not true? Count 2 alleges that you failed to immediately report to the probation officer your address change. Is that true or not true? Count 3 alleges that you provided a urine sample October 29th of 2025 that tested positive for marijuana. Is that true or not true? True. Count 4 alleges that you provided a urine sample March 4th of 2026 that also tested positive for marijuana. Is that true or not true? Count 5 alleges that you admitted to your probation officer that you were using K2 or synthetic marijuana on March 4th of 2026. Is that true or not true? Count 6 alleges that you failed to provide verification of completing the community service hours as required. Is that true or not true? Count 7 alleges that you're behind in your court-assessed fees as of March 4th of 2026 in the amount of $2,020. Is that true or not true? Count 8 alleges that you failed to report in person to the Harris County Probation Department February 12th and February 26th of 2026. Is that true or not true? And then count 9 alleges that you failed to report to Jefferson County either online or by mail for the months of May of 2025 and then January and February of 2026. Is that true or not true? Did you enter your pleas of true to counts 1 through 9 freely and voluntarily? Did anybody force you to plead true to those counts? Well, so did you plead true to those counts because they're actually true? Okay. I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? You fully understand them. And you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal. State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Newell is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1 through 9 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time I'm going to revoke your probation, reassess your punishment in accordance with your agreement to a term of 18 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows that this was an agreement that I followed, so you did waive your right to appeal. You've probably already received the other, but just in case, I handed you the admonishment regarding your ineligibility to possess a firearm or ammunition. So because you have a felony conviction, you're ineligible to possess a firearm or ammunition. If you have any questions about that, read that document or ask Mr. Rojas. All right. Good luck to you, sir. You can go back with the bailiff. Thank you for being here. Good morning. Are you Rosendo Ochoa? And will your client waive the formal reading of the motion?
He will, Your Honor.
Mr. Ochoa, in cause number 24 DCCR 0367, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation June 23rd of 2025 for evading arrest or detention with a motor vehicle, a third-degree felony, and that was a 5-year deferred probation. Is that correct? The state has elected to proceed on counts 2 through 5. Count 2 alleges that you violated your probation by failing to avoid injurious or vicious habits. Wrong one. I'm sorry. Count 2 alleges that you provided a urine sample on December 10th of 2025 that tested positive for tetrahydrocannabinol. And is that true or not true? Count 3 alleges that you failed to provide verification of performing the community service hours required. Is that true or not true?
False.
I'm sorry?
True and false.
How's it true and false?
I just didn't finish.
You didn't finish it. So we'll just do not true then for count 3. Count 4 alleges that you failed to provide verification of entering and successfully completing the moral recognition therapy. Count 5 alleges that you failed to pay. So you did the MRT program and finished it?
No.
So how's that false?
Oh, true.
It's true that you did. True.
Okay, so you did not complete the moral recognition therapy. So that would be true. That was a violation. All right, so count 2 and count 4. Count 5 alleges that you are behind in your court assessed fees as of February 18th of 2026 in the amount of $500. That's true. Did you enter your pleas of true to counts 2, 4, and 5 freely and voluntarily? And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas? And obviously you understand if I follow this, then you can't change your mind later and appeal or anything like that. So it looks like the agreement that you've reached is for me to continue you on probation, order a 45-day sanction in our jail, and then you would be back on probation and hopefully following all the rules and doing better. Is that your understanding?
Yes.
All right, then at this time, I'm going to find that you entered your pleas of true to counts 2, 4, and 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to give you this opportunity, so this is your second chance. I don't want you to think you're going to get a third, okay? I'm going to order that you serve 45 days in jail. It looks like you probably already have credit for that. You'll get credit for any time that you've been in since this arrest on the MTRB, okay? And then you'll be back out on probation. I do want some type of substance abuse assessment done based on that positive test. If there's something that probation thinks you need to do to make sure that you stay clean, you are going to be required to do whatever that is. Wear a drug patch, go to classes, be in the drop program, whatever. You understand? All that's meant to make sure that you do better and successfully complete this probation. You still don't have a felony conviction on your record, but you're getting closer to getting one if you keep violating. You need to get that MRT program done. I want it started within 30 days of your release from jail. So we're not going to put it off to the end of probation. I want it done. Okay. All right. I'm handing you the trial court certification that shows this was an agreement I followed. So you did waive your right to appeal. All right. Good luck.